This podcast is not intended to be legal advice, but instead offers general observations and educational information. If you are seeking legal advice, consult with a licensed attorney in your jurisdiction to discuss the specific facts of your case.
Hi everyone, this is Aisha Dennis.
And I'm Daryl Austin.
And we're here again with another episode of the Do Not Consent Project. We'd be remiss if we didn't mention that this is our first episode we're recording under a new administration.
That's right.
So I think I can speak for both of us and say we're pretty happy about that and pretty excited in particular about having our first African American or Black vice president who's also Asian, who's also a woman. And so we're super happy about Kamala, and I've heard some people even today still mispronouncing her name, so I hope that we can all get behind the right pronunciation, which is Kamala Harris. But also I'm very excited for Biden and his whole team, and it's the most diverse administration that we've seen probably ever. So I think it's going to be a good next 4 years, or at least better than the last.
We're definitely optimistic and hopeful.
Yeah.
For some things to change and progress in the right direction, particularly in the law, but society-wise as well.
Yeah. So, as always, we like to start with the Do Not Consent campaign. And we want to make sure that our listeners and our viewers know that we really should not be consenting to police searches. We've covered that topic with regard to automobiles. So when you're driving your car on the road and you get pulled over. We've also covered it in regard to home searches. So if they show up at your house, how do you handle it? And then today we want to cover it just as a pedestrian. So you're walking the streets or in some way you just encounter a law enforcement officer. How do you deal with them asking you to consent?
Or appropriately respond. And so typically, police officers, if they ask you for your ID or anything like that, they also will ask, do you have anything on you that I should know about? Mm-hmm. And then that's almost like a consent to search, where you are willingly saying, no, or they'll say, I'll pat you down for officer safety. And I think that's a good way to protect the public from maybe a weapon could be found or something other than drugs. It's not always drugs they're looking for. It could be a weapon. And so they need to know, what to do in that encounter.
Yeah. So just with regard to what Daryl just said, if they're patting you down, they may not really have a good reason. But whether they do or do not, obviously you want to comply if that's what they're doing. But if they ask you, hey, do you mind? Can I search you? Or even if they ask you, do you have anything on you? You can say no. Don't just go voluntarily pulling your pockets out or opening your bag or handing them anything. Let them ask you, well, can I search? And if you get a question like that, certainly say no. If they just say, we're going to search, you might say, well, do you have to, do I have a choice? Just to make sure they understand you're not consenting. And you can also just say, I don't consent to the search, but, do what you need to do, officer. So, Daryl, why don't you throw me a hypo?
In terms of do not consent?
Like as a pedestrian.
All right, So
I'll be the suspect.
All right. What usually, the hypo that I can think of is kind of like the whole stop and frisk. In New York City.
And that's a hypo, but I want to reenact it.
Yeah, I'll give you a hypo. I mean, this is just everyday occurrence. The police at that time, and who knows if they're still targeting it in the same manner with the same zealous nature, but they were targeting young males, African-American males or Latino males for weapons. And a lot of people carry a weapon for protection. In the city, we all take the train. And so a cop may come up to you and see a clip. Mm-hmm. That may or may not give a cop reasonable suspicion or probable cause. So maybe we should start with that. What does that mean for a pedestrian?
Some lawyers can barely explain this. I'm going to try to explain it, but it is a complicated concept. But basically, to make it simple, it's just, do they have a reason to believe you may be committing a crime?
Okay.
And so they probably wouldn't have a reason to believe it just because you have a clip, I would argue. But if they had a report from someone who said, hey, there's somebody in the subway station who has a gun, and then they see me and I have a clip on, then at that point they might have reasonable suspicion to think that the clip I have on is a gun
or a knife. So in New York, the knives are illegal if you can flick it out and it locks in. It's a gravity knife is what they call it.
I'm committing a crime.
They
think I might be.
You might be, unless you use it for work. But that's a basis they will claim to.
Everything is complicated with lawyers.
So with you, I'm a cop. I see you have something clipped. It could be a pen. It could be anything. But based on my training and experience, this is language you will always hear. I think it is a gravity knife. So I ask you for your name and ID.
Sure. My name is Aisha Dennis, officer.
Do you have any ID? Yes.
Here's
okay.
my ID.
Now, Ms. Dennis, do you have anything on you that I need to know about?
I do not.
Okay. You don't mind if I just do a quick pat down for officer safety?
I do not consent to a search.
Okay. What is the problem? I thought you don't have anything that I need to be worried about.
There's no problem, officer, but I do not consent to a search.
Now, two things with that. The officer is either going to pat you down or not. But it's also your tone is good. I noticed you're calm. You're not hyped up. You're not super aggressive, and I think that's also important for our public to understand, our audience to understand. The energy you give to the officer is important because that will oftentimes dictate the energy you get back.
Yeah.
And so you're very stern. You lied, maybe. In our scenario,
it doesn't matter whether
I
I lied or not. Whether I have a gun on me or not, I'm not consenting to a search.
Okay.
But, in reality, in the situation you're giving me where you have reasonable suspicion, they're going to pat you down anyway. So I'm not saying if the officer says, I'm about to pat you down, you say no. I mean, he's going to pat you down if he thinks that you might be committing a crime. But if, let's say there wasn't a report, he just sees this clip,
just sees a clip.
Or, he just wants to come bother you for no reason at all. And he asks you, hey, if you don't have anything on you, do you mind if I check?
You do mind.
I do mind,
Absolutely.
and I do not consent.
And I guess, am I free to leave? I've given you my ID. I've identified myself. Am I free to go?
I love it. I think that's a great question to ask.
Okay. So we are recapping, and so we know that we do not consent to car searches. Everybody needs to know that if an officer comes to your house, you're not letting them in, and doesn't matter who answers the door first. Everybody in that house needs to know you're not letting officers in without a warrant. And now, if you get stopped in the street, you have the right to ask, am I free to leave? I've identified myself, but if he asks, do you mind if I search your bags or your purse, pocketbook, whatever, or even a pat down, that you can say, I do not consent.
Yes. And one other thing I'll add that is kind of a newer issue these days is the searches of your cell phones, your computers, your tablets. They may say, hey, we just want to check to make sure you don't have a phone call from this person, or we want you to, let us look in your phone and see where your locations have been lately or whatever. Do not consent. Don't give them your phone. I mean, they may say, hey, we want you to give us your passcode so we can get into your phone. Do not consent to these things. If you have an option, just say, I don't consent. I do not want to give this to you. Now, if they force you to do it, nobody's saying don't do what an officer is telling you have to do. But don't voluntarily give up access to your devices, because you would be surprised, or maybe you wouldn't be surprised, but there's just tons of data and information in your electronic devices that could potentially be used against you in a case.
And just as a final thought, we're doing this to protect the public. We're doing this because we do not want to submit to a police state, so to speak. But these are your rights. They're hard-earned, fought for rights. And what ends up happening is your innocent consent can turn into something detrimental to you or your family. So that's why we want to make sure everybody understands you do have these rights to say no in terms of police searches.
Yes. So last time, Daryl, we were also talking about the anatomy of a case.
Right. And so we've basically stopped at the halfway point. And so to continue on with part 2, we left off with an
And why don't you just just so everybody's clear, the anatomy of a case was just walking through a criminal case. I was playing the client. I think I'm
the attorney. I'm the client.
Oh, sorry, I'm the attorney. And what kind of client are you? A felon in possession.
I'm a handsome
Here we
felon
go.
that has been caught with a gun in a car that I was in.
Okay, and as a felon, he cannot possess a firearm, and so I have him as a client. This is all hypothetical, but I have him as a client in a felon in possession case in federal court.
Right.
And so where did we leave off?
We left off with you had identified some strong defenses to the case. The prosecutor has given a pretty sweetheart deal for a federal case of probation, and the client has told you, has changed his story that from I didn't know anything about the gun to I knew there was a gun. And so we are now at a crossroads. Do we go to trial? Do we take a plea? Do we try to litigate this issue of suppression or something like that to maybe get the case dismissed without having to go to trial?
Right. So, what I would say to you, Daryl, is you're telling me you're innocent.
Yes.
And I'm not God. I don't know what the truth is. But I believe you. I have no reason not to believe that you had no ability to access and control that weapon, that weapon was really under somebody else's control. And so if that is your story and you're sticking to it, which I fully respect, then my advice would be you need to fight the case. Now, I have to give you that advice because if you wanted to plead guilty, you're not going to be able to plead guilty without actually being guilty. In a federal court, you can only plead if you're actually guilty, and you have to tell the truth and be guilty.
So we're still dealing with anatomy of the case, but let's make sure we don't say, well, that doesn't happen in state court. So a lot of times in a trial setting, we'll deal with snitches. People know what those are, or cooperators. And, you can go through their background, their rap sheet, whatever, and they'll say, oh, I pled to that because I had a sweetheart deal, but I didn't do it. And one of the things I like to say is, well, if you pled guilty, you did it, right? You had to walk through an allocution. You don't get the benefit of now saying after you got that sweetheart deal, I didn't do it. Mm-hmm. And that's in terms of cross-examination, meaning trying to point them out as somebody that's interested in the outcome against your client. Why is that any different in federal court than in state court? Or is that theoretically different?
I don't think it's different at all. I mean, I think it's a hard thing to hear you talk about it because I think there's theory and then there's practice, right? I think in practice, people plead guilty all the time, including in federal courts.
Absolutely.
When they are actually innocent. But, in order to do it, they have to, there's this fiction of, you have to be guilty to plead guilty. And so as attorneys, we have to say, you have to be guilty to plead guilty. And the judge has to say, you have to be guilty to plead guilty, even though the system is so coercive that I think just having common sense, you have to know that some of these people who are facing a probation offer versus, 15 years in prison or whatever it might be, are going to, when they change their story, they're changing it not because they're actually guilty, but because that's in their best interest. And they have, just the way the rules work, they have to say they're guilty. So, I think you make a good point that moving forward, once you've pled guilty to something, it's going to be almost impossible in a legal setting to say you're innocent of that.
There's no
it's not completely impossible, but it is almost impossible unless you get some evidence of innocence or something like that. Even then, it might be tough. But I do think practically, I hear you when you tell your clients that because you want them to know we're not going to get in front of a judge or a jury and convince them that you're not guilty of something you pled guilty to. But in reality, I think you probably understand. A lot of your clients probably did plead guilty to something they didn't do.
And it hurts them because it makes their exposure to higher sentences. And when they come in through the federal system, it's also an issue where the federal system is not as turnstile as in the state. So the cases take a little longer, just naturally. There's more investigation typically, unless it's like a case that was plucked from the state and the federal government is deciding to prosecute you. So there's this idea of, I'm just going to plead guilty to get it out of the way, doesn't necessarily work. But in our hypothetical or our case anatomy, I'm still maintaining that I'm innocent.
Right.
And so you've advised me, fine, if you're innocent, these are your options.
Yeah, if you're innocent, your only option is to fight the case.
Right, but we don't have to necessarily go to trial. So
right,
I'd
you
like
wanted to file a suppression motion, I
right,
think.
so at this point, I'd like you to file a suppression motion.
Which is just a motion to try to keep evidence out because of some constitutional issue with how the officers secured the evidence.
Right, and so that was like legalese.
Sorry, but basically,
That
say
was
the
cop
cops stopped him for no
Illegally,
good reason at
yes.
all. Then we could file a motion to say whatever evidence they got as a result of having stopped him for no good reason should be thrown out.
Right, and that would mean the gun, because there was no basis to stop me. We would file a motion in my case, in this situation, to ask the judge to throw out the gun, more or less. Keep the gun out of a trial. And without a gun, there is no trial. So I like that idea all the way.
Right, but in letting the prosecutor know I might file the motion or in just filing the motion itself, if we were to lose, first of all, at that point, the prosecutor might, I don't want to use the word retaliate because that's not a good term to use as a lawyer, but
They may supersede
they
the
may
indictment.
respond, that's a better word. They may respond by, charging you with more. So you're looking at more, you have a larger exposure in terms of your penalty. And even if they didn't, certainly withdrawing any plea offer they've given you, because you're making them work. They're not trying to do that. So they're going to take away any plea offer. And then the third thing is, even if they didn't do any of that, once you get to sentencing, because you litigated a suppression motion or anything else, you might be, it's a little questionable, but there's a risk that you'll be looking at a higher sentence just because you fought the case in some way.
Right, so that means a trial tax is something we've heard.
Trial penalty
thrown around. And in theory, in federal court, there has to be a trial tax of some kind because they reward you for pleading guilty, and that reward is based on levels taking off of your offense. So without getting into the into the nuts and bolts, in federal court they have what is considered to be a guideline sentence. So this particular crime may have a guideline of 2 years. And
that's just a recommendation for a sentence.
And that's a recommendation for a judge. So he's looking at what he would say 2 years, 24 months to 2.5 years, 30 months. That's if you plead guilty. I mean, yes, if you plead guilty. If you don't plead guilty, that range is necessarily higher because you don't get the thank you for allowing us to use our resources in something else or another prosecution. So you no longer lose those 3 levels. Those 3 levels could be another 6 to 12 months. So that is a potential trial tax that you're automatically starting with.
Right.
Without it being anything nefarious, it's just the way the guidelines shake out.
Right. So bottom line is, in asserting your innocence, you do have to have some courage because it's a little risky if you were to lose the fight.
Time is going to automatically tack on the starting point.
Right.
But I'm
So
happy. I'm happy. You're my lawyer. You got me a bond. You're not pushing me to plea, which I appreciate. I didn't like you talking all that 0 to 10 stuff. That was a little scary. But at the end of the day, you did find something that I think this is a good shot. I don't have to worry about jurors necessarily not believing you or not finding the real truth of it. Right. And so we go through. I say go forward with the suppression motion.
Right. So I filed a motion. I'll ask for a hearing. Hopefully the judge would grant that if he thought there was a reason to have the officers come in and testify. If there was something in dispute that he needed to hear about, which usually, especially in a traffic stop, there will be, because the officer is going to say, well, I saw X, and it's like, well, how could you see that? The windows were tinted. So there's something we need to get in court and talk about. And so we'd have that hearing. You'd be right next to me. You write me some questions that I could ask the officers if you wanted me to, but otherwise I just rely on my skill set, ask the questions, make the arguments to argue that the officers violated the law, and the judge would either issue a ruling from the bench, so while he's, right in court, or he or she, I should say, may take some time to think about it, and then come back with a written ruling later.
And obviously, if they rule in our favor, the case is over. And if they
For
don't,
the most part, yes.
yeah, I mean, if the gun is out,
Yeah, then
that's
there's
the
no
end of the
real
case.
felon in possession case.
Right. They can try to go forward, but that would literally be asking for the judge to yell at them and say you're wasting time.
Right.
And
So
resources.
what normally would happen is the judge would issue a ruling, and the ruling would say the evidence is suppressed, it gets thrown out, and then the prosecution would file a motion to dismiss the whole case.
Right. And so that would be an example where you beat the feds in that case. Let's assume the judge decides it's a close call, but I am not going to suppress.
Right.
So you now advise me what my appellate rights and what else I can do for trial.
Right. So in your instance, it seems like your whole challenge to the case is rooted a lot in, it wasn't your gun, right?
Correct.
It was someone else's gun. They had control over it. They had access to it. And so I would just let you know that is a potential defense. I'd obviously let you know what the risk is of going to trial, so you be well aware that as an innocent person, your only option, as long as you're telling me you're innocent, is to go to trial. And so I prepared that defense as best as I could.
One of the other things I would maybe add is, the idea of trial strategy. And I would get the client's input. And I would show them all the bad facts that the government would be bringing out that makes it look like your gun. Right. It was under your seat. It was, in your car. All those things that could be misconstrued as your weapon. And, I was a passenger. Maybe they get the driver to come in and say, well, it was his gun. It was his car. It was his gun. Those are things that we would probably have to discuss. And the client, for me, would have to be comfortable with going forward with all that evidence that they are now aware of. And not saying that it's like a mountain of evidence, but it is probably enough to meet their burden of proof in just
Which
straight.
basically just, you say that and sometimes I think people get confused, but it basically just means they could win.
Yeah, there's enough to suggest
they could win.
that they can prove the elements. Whether it's proof beyond a reasonable doubt is a different story. But they got probable cause for an indictment. That's more legal talk. That means basically it's more likely than not it's your gun. And they could set forth.
No.
That's probable
not
cause.
what it means that there is a reason to believe it could be your gun. Probable cause is a very low standard.
Okay. If you want to make it even less, that's even better.
Yeah.
I'm not going to fight you over that.
Okay.
There's probable cause to believe it's your gun based on whatever evidence they put forward. In this case, it's your car. It's two people in the car. The other passenger, the driver says it's not my gun. It's his gun. It's his car. That's evidence of some nature that they could put forth to a jury to sustain a conviction.
Right. And talking to the client, obviously you do put forward what the bad evidence is against you. And one of the reasons you do that is to see what the response is, because they may say, oh, it's definitely not my gun. You just go on his Instagram and you can take pictures from there and you can see that he's the one who always has his gun. Or if you talk to his sister, she's my friend, I'm sure she'll tell you. So send your investigator out there to do that. And so while you're seeing the government's case, you're also strategizing around how to defend it. And also showing the client that so they'll know, okay, what do we have versus what does the prosecutor have. Not to say that we have to have anything because it is their burden to prove it. But as a good defense lawyer, you do want to try to counter some of that evidence if you can.
Right. So, this is just I'll call it a typical example, but it's not really a run-of-the-mill case. Anybody looking at any amount of time, felon in possession, you could get 10 years. Like, you really could. That offer of probation.
Or more.
Or
Depending
more,
on your criminal history.
but depending on your criminal history, you're starting off with a maximum sentence of 10 years. That could absolutely happen. God forbid the gun is stolen. All these other things could tack on time onto your case. And so there is a real risk from going from probation in the very beginning to potentially getting a 10-year sentence. And that's a heavy burden on the client especially, and then on the lawyer if he cares about the client, I would say.
Yeah. And so a lot of times people, they do fold in these cases, and then they'll say they're not innocent anymore, and they want to plead out. And so, after we had a trial, if you went to trial after we had it, if we lost it, hopefully we wouldn't, but if we lost it, you go to sentencing. And if you pled out, we go to sentencing. And even if you had an offer from probation, usually in the federal court, especially at least the ones that we're aware of, the judge isn't going to take a plea that binds them to, like, forces them to give you probation. It would normally just be a recommendation. And so sentencing, long story short, is going to be up to the judge, whether or not the prosecutor and you agree about probation or not. The judge is still going to be able to sentence somewhere between 0 to 10 years. Like Daryl said, they will have a recommended range, so that might be that 2-year recommendation that they'll rely on heavily. Or if the prosecutor is recommending probation, a lot of times the judges will give you that.
Yeah.
But either way, you just need to know that, at least in the federal court, sentencing is completely up to the court. And then that would be the end of the case.
Yeah. I mean, and that's obviously a quick, bare bones example of, intake to sentencing. We didn't get into too much of what what goes into sentencing. Perhaps we can discuss that a little bit later in terms of mitigation, in terms of putting out the client's story. Trial strategy, again, it's more about telling a story. I think the first person I ever heard say that was an attorney named Tony Rico out of New York. Him and Xavier Donaldson actually were doing like a CLE or some kind of a speech, and I heard them discuss it. And he's like, you really got to tell that client's story. And so you're thinking from the beginning when you meet that client, what is their story? How am I going to represent them properly? How am I going to connect with them and have a jury connect with them or a judge connect with them, even if they are guilty, and get the best outcome possible for that person, whether it is a plea or it is, trial.
Absolutely. And
So-
if y'all have specific questions about that storytelling process or sentencing or even trial strategy, we're happy to discuss that as well. But I know there was a recent case, or a case that recently got sentenced, the Pastor Kirbyjon Caldwell case that you've been following. So I think it might be good to just talk a little bit about that case.
Sure. Can you pull up my screen there, DJ?
1 second.
Producer.
Producer extraordinaire. Thank you. So, Houston, Texas, in particularly knows about Pastor Kirbyjon. He was a very well-regarded pastor for George Bush and Barack Obama, President George Bush and President Barack Obama. He was spiritual advisors to both of them. And he led a I don't know if we want to call it a mega church, but it's a pretty large church in Houston called Windsor Village. And unfortunately, he was charged with conspiracy to commit wire fraud, and money laundering out of Louisiana in I think Shreveport.
Just to break those charges down a little bit, basically wire fraud is when you're moving money across state lines, basically, usually just across banks, that or that's part of a scheme, or part of like I don't know what's another word for scheme, but just part of like a strategy, I guess, to commit a crime. Mm-hmm. And money laundering is moving money that is a part of
some ill-gotten
gains. Some unlawful
So
project.
And his charge essentially was these Chinese bonds that they had, these pre-war Chinese bonds. And I've seen, some financial news outlets talking about Chinese bonds as recently as like Monday. And I thought, wow, he just pled guilty, and now they're saying this could be a good investment, like the Financial Times or something like that is actually saying this is a good investment. The issue with it is these pre-war Chinese bonds. He knew, and his co-conspirator, his co-defendants knew that these bonds were essentially worthless. And
that's the allegation.
Well, he pled guilty, so at this point, again, you don't get to plead guilty and then say allegedly, right? Like that's
well,
what he
you
pled
can plead
guilty
guilty to that charge also if you knew or if you were willfully blind.
Okay.
And so willfully blind basically means like I had really good, strong indicators that this was something illegal, but I put my head under the sand and I didn't ask questions because I didn't want to know. So it'd be the equivalent of like if somebody said, "Hey, can you come pick up this car, drive it from point A to point B? I got some really, very, special stuff in my trunk. but don't open it because I don't want you to really know what's in it. And you're like, okay, and you don't ask any questions, you don't open the trunk, and next thing you know, you drop it off and somebody gives you $300 and you're on your way for just having driven a car from point A to point B. That's being willfully blind, because you can pretty much figure out that you're consciously aware that there's probably something illegal going on, and you're making the decision not to look into it further.
Well,
so you can plead guilty to it for that as well.
Well, in conspiracy, though, you do have to join in the conspiracy, join in the illegal enterprise. You can't be willfully blind and being a member of a conspiracy, because it requires knowledge. Which is
I'm going to disagree with that, but we don't got to get stuck on it.
You can disagree. You can check later on. But for now, he pled guilty to conspiracy. The conspiracy, or the co-conspirators, were telling members of the public, if you invest, let's say $50,000, you'll get a $3 million return on these bonds. And they used his name and his status in the community as a businessman and as a preacher of a congregation to, I don't want to say dupe, but to influence these other investors to giving up $50,000. And we had people give like 180,000, 50. I say we, but in the indictment it alleged 50,000, 180,000, 190,000, so on and so forth. And that's where the wire fraud comes in, because that money was wired, and the promise was $3 million, which should have, caused alarms to go off in their head. It didn't. And ultimately, they were charged.
Let me pause you there. I feel the defense lawyer coming out of me, and I know Daryl is just telling what the prosecution side of the story is, and when you plead guilty, for the most part, it's the prosecution side of the story that prevails. But I will say that often, especially in like these types of fraud cases, and I don't know much about this particular case, but I would say often in these fraud cases, there's this strong story from the prosecutors that, you knew what you were doing and you were trying to defraud these people out of their money and yada, yada, yada. And often it's a little more gray than that. Often it's like in the beginning, maybe you thought it was all legit. Maybe you put your money in, you invested as well. And then at some point you just kind of got in over your head and you realize like, oh, this is not legit, and you're trying to figure it out. That might be one example. But long story short, often it's gray. And you talked about storytelling. You try to tell that story at sentencing to a judge, so the judge understands how that happened. But it's really hard for me to hear you say it the way you're saying it, because you really are giving the government's side to the story. And at the end of the day, when you plead guilty, you're not pleading guilty to the whole prosecution story. I know that's how the news media will tell it, but you're pleading guilty to, there was at least one piece of this that was fraudulent, and I knew, or I consciously ignored, evidence that I shouldn't have ignored to show me that it was fraudulent. And, for this one particular piece, I'm going to go ahead and plead guilty. And then from there, the prosecution can tell their side of the story to give the full picture. You can give your full picture. And then the judge makes a decision about what sentencing should be. So but often there are separate stories between the government and the defense, even when you get to sentencing.
Then the question becomes, what does the judge ask that you allocute to? Right? If you're going to go in and plead guilty and have this theory that I didn't really know, you're not going to get through a guilty plea.
Okay, so that was getting a little complicated, but basically there is. So you go into a guilty plea. And every judge is different. Well, not every judge, but they vary in terms of what they accept from you in order to get you to plead guilty. Right. And I've done. I know Daryl has too. I mean, Daryl. We're not gonna get into it, but we've done these pleas before, and we've seen other pleas from other.
I've seen these pleas done before.
Right, you've seen them done before, and they're done differently in every court.
Yes.
And some courts just say, did you know something was fraudulent, or should you have known it was fraudulent? You didn't, and you were part of this thing, and they say yeah, and that's it. Others may require more detail.
Let me just go back. People investing $190,000 or $50,000 with the promise of a $3 million return should be ringing off bells in your head.
You haven't seen the evidence, so that's the
No,
one side of the story.
I don't need to see evidence to know $100,000 investment.
But that's what they're saying. They promised them. They might not have promised them that. Was that in writing, or did somebody just say that?
That is
everything is gray.
No, it's not gray. It's in the plea agreement. It's not gray.
Oh, it's in the plea agreement?
Yeah, and it's what the facts that they will prove at trial. That's in the plea agreement. And the indictment
I didn't
has
see
it.
the plea agreement, so
Okay, well.
why don't you start there? What did the plea agreement say?
The plea agreement is I plead guilty to conspiracy in count 1, which has all of that information in there. The conspiracy to commit wire fraud. The wire fraud is getting people to send $180,000, $50,000, $190,000 with the promise of a $3 million return in a pretty short period of time. Like in one case,
yeah, but a lot of times,
said like, well, hold on. In one case, they said you'll get $3 million for this $500,000 investment. That person didn't invest $500,000, but then they came back and got $50,000 from somebody and said, in 2 months you'll get $3 million. That person should have bells ringing in their head to know a $3 million return on my investment in 2 months is extraordinarily high, or you don't need to be investing. That's why if I am an investor that has $50,000 and it doesn't ring bells in my head, that's how a guy that like Kirbyjon or his co-defendant, really, because Kirbyjon is not the one tricking these people. That's how they can be tricked. But a normal investor would know better than to think $100,000 and $3 million back in 2 months is very, very abnormal.
I'm gonna tell you what. Me and Daryl are gonna disagree about how much I'm gonna sit here and believe all of this narrative. Because again, the storytelling from the prosecutor's side. I mean, it could be 100% true, but usually in my experience, it's somewhere in the middle.
Yeah,
but what I would say about you cut me off. What I would say about these types of cases.
Yeah, but
what I would say about these types of cases, wire fraud cases, is they are difficult cases because it ultimately comes down to what we call mens rea a lot of times, which is mental state. What did you know? What were you thinking when you did it? And Daryl, I looked up a little bit of this stuff, and I don't know. This is one side versus the other side. We don't know what the facts would have borne out, but my understanding is this man was putting in his own money. So if he's putting his own money into this stuff, then maybe he got duped too. My understanding is that he had people advising him that this was okay. I mean, as you just talked about how people say these Chinese bonds or whatever. So it would come down, if he were to actually try the case, or if in another case, whether it would be tried, it'd come down to what would a jury think he knew or not should have known, but was consciously kind of aware of and disregarded. And so I get that there was a guilty plea in this case. As we just talked about, people plead guilty all the time. But in terms of what the actual truth, bottom of the line, like what actually happened, I think a lot of times you don't really find that out until you have a trial, you have all that stuff kind of just thrown out there, litigated, and in this case you don't. And so as far as I can tell, Daryl, you're relying on the government story, which I understand the person pled guilty, so you have a right to do that, but I as a defense lawyer, hearing it, I'm just not, I can't accept all of that story.
I think you should accept it when the client tells you I did it. He did it.
If that was his story, fine. If that was his story, but did what?
Well,
did he do
I'll
what?
give it to you this way. Let's say you represent his co-defendant. He gets on that stand. You think are you now all of a sudden going to say this is a gray area? Or are you going to say, you know what, you took those people money? I mean, how would you
play your role as a lawyer. You play your role. Right now, I'm just kind of a neutral observer. And all I'm saying is the man pled guilty.
Yes. How do you overlook
which would
him
indicate either
guilty?
that he thought going to trial was too risky.
For a pastor of a mega church was too risky?
Look.
You think it's more risky to go to trial and profess your innocence with a congregation of support?
He paid his restitution. He has a life of such great public service. Mm-hmm. I think they thought they had a really understanding judge. Who knows what the prosecutor said that they were going to say at sentencing, okay? And my understanding is his co-defendant pled guilty before he did.
All right. So where are you
Wait,
getting
I'm not
that
done.
information
I'm not
from?
done. Google.
Oh.
So articles, news articles, Houston Chronicle, and
Google
can I
scholar.
finish? Can I finish? He's got my producers rolling. So
Okay.
if you have a co-defendant who's already pled guilty, 9 times out of 10, they've cut a deal that they're going to talk on you, that they're going to testify against you, whatever. I'm not saying that's what happened, but a lot of times it could. So you have a whole bunch of other things going on at the same time that might make you think going to trial at this point is risky, and maybe I think I can get a really good outcome from this judge based on the fact that I have all this public service and I paid all my restitution. So who knows why somebody pleads guilty? I don't know. I mean, but as lawyers, we have to assume that if they pled guilty, and I'm saying as lawyers as opposed to being human, but as a lawyer, we have to assume that they pled guilty, they did something wrong. That they literally did something wrong. But just because I can assume that does not mean that I think he pled guilty to every single ounce of what the government story was.
He pled guilty to the conspiracy. And as a lawyer, as a defense attorney...
But you can plead guilty to a piece of a conspiracy.
Okay. And as a lawyer and as a defense attorney, I can assume one thing. Innocent people don't plead guilty.
You can assume that, but then not as a human.
Hold on.
Not as a human, you
but
can't
as a
assume
lawyer, I get to make that assumption. And so when you go into court and you say, I am pleading guilty to conspiracy, no one forced me, no one coerced me, and then they walk through, well, what did you do? Well, I took these people's money and I invested it and I bought a house and all this other stuff with the money. I don't know what he did
That's
exactly.
not what they said he did.
But hold on. He has a house. They were looking to forfeit a home in Houston. Did you see that?
I didn't see that. No.
Okay, so they were looking to. I'm just telling you. They were
What
looking,
I saw is that they said he
Hold
was
on,
paying his debts down.
hold on,
That's what I saw.
They were looking to forfeit a house in Houston if he didn't pay the restitution amount within 10 days of being sentenced. So he had to pay that money before, otherwise he loses the house. So they probably have some reason to believe some of that money linked to whatever that home was. And so all I'm saying to you is, as a defense attorney, I'm pretty strong about this. Innocent people don't plead guilty.
I mean, you can say that, Daryl, as a defense attorney, and we can have this conversation as lawyers, but as humans, we know that so many clients, particularly in these types of cases,
Yes.
cut deals and plead guilty to charges that they aren't necessarily guilty of because they think it's too risky to go to trial against a cooperating co-defendant, and also based on this notion of, even though it looks really bad, I didn't really know what I was doing.
Right. And so that grace you're giving them will backfire when that person that you just gave that grace comes in 2 years later and says, well, I want to cooperate against somebody else.
What
You're
do
a
you mean?
client.
But
And
that's a whole different
hold on.
situation.
It's not.
It's like apples and oranges.
It's not,
Yes, it
because
is.
he will
Like
then
bananas
he
and
will
strawberries.
testify as a cooperator for the government.
Somebody else's client.
No, your client, and he's cooperating against your
A
guy.
new client.
Yeah, a new client. And he's going to be saying, well, I only pled guilty when you cross-examine him about you're just doing this to get out of jail sooner. It's like, well, you know how it is. And you can't be on some, oh, no, I don't know, if you're advocating for gray area.
Well, the point
now.
is, context matters, right? So, there are cases where somebody is like super culpable and that might not be your client, and then you have your client who's kind of there but didn't really know what was going on. And so it could be the case that or let's switch it. So it could be the case that if my client goes to trial and then this person is wanting to say that my client knew all this stuff, then I'm going to get into them, and as I'm cross-examining them, and I'm going to point out all the reasons why they be lying and why my client really didn't know.
Or he's not
but
lying.
that's not the situation we're
he's
in.
Being the gray. I don't know what the situation is other than he pled guilty to conspiracy.
The
to
situation
commit
is
fraud.
you are reading an indictment or whatever document you
The
read,
plea agreement.
and you are assuming facts
In the
are
plea agreement that he
completely
signed.
thoroughly true.
No. See, that's the thing. If there's a plea agreement and you affix your signature to it, I am able to use that as a basis to believe whatever you pled guilty to.
You are.
Right. So I'm not
As a
interested.
general public, you are. And all I'm saying is that in these types of cases, I just want to point out that is usually somewhere in the middle, is usually gray.
Okay.
And that's it.
I'm sure it is gray,
he
but
ended up getting 6 years.
He got 6 years
Which
for
is quite a lot of time.
for a gray area.
And
He's
that
facing
takes us
lot
to a
more than
topic
6 years, so.
I really want to talk about today, which is prison abolition. because that's a topic that one of our viewers gave us. It's something that they wanted to hear about. And so, I think his case may be a good example of just, introducing this topic, because does a person who has that kind of history, right, of public service, and yet, does this egregious act that he pled guilty to, does that warrant putting him in jail? I think the article said he's fighting cancer or something. He's older. Is this a person who needs to be locked inside of a cell for 6 years?
Is Bill Cosby a person that needs to be in the jail?
I'm asking the question. I love how people answer a question by asking a question.
Just
does Bill Cosby need to be in jail? I mean, that is the question.
Right. Make the case. I don't, I'm willing to absolutely learn or delve into this. I would assume maybe not. Financial crime case, maybe there isn't a basis to put somebody in jail for 6 years. Or, I can see how he and Bill Cosby's cases are completely different. One is dealing with violence to a young lady. The other is fraud to to members, maybe not members of congregation, but members of the public. So in terms of the violent nature of it, they're not the same. But in terms of age and what jail is supposed to do, maybe they are the same.
Yeah. I mean, I don't want to just limit it to them. I mean, we can just think about prison abolition for all different types of offenders.
So what does that really mean? Is that like get rid of jails, or is that more like defund the police, where we're saying spend less money on jails?
I don't know, maybe a little bit of both. I think it is reimagining the world that we live in, society in particular that we live in, without it being an incarceral state, right? So trying to imagine a world where we don't deal with people who, we want to control, right? There's certain communities we want to control, or, that we feel like are having certain behaviors that we don't like, by throwing them into a cage and locking the key. That we would deal with it in a different way. And I think, I used to be a teacher, high school teacher. And when I first started teaching, I think about it in this way, like, I had kids who would come in and act up, and I just like, all right, you can get out. Bye. Leave, And I think to a certain extent, that's what we do with our society. Like, you're acting up, all right, bye, leave. But the kid, she's not learning anything, or he's not learning anything. Like, I'm not solving the problem. They're going to come back the next day with the same issue. And so, in that same way, our prison system is that way. Like, we're not really solving anything by locking people up in these cages. And if anything, we might be making them worse, right? We might be, subjecting them to more violence in prison, or just to, like, psychological abuse or whatever it is. And so when they get out, not only to mention that they've had that experience, they now also have this second-class citizenship of being a felon, of, having these, what we call collateral consequences, but consequences of those convictions, which means that, they'll have a hard time getting a job, or they'll have a hard time, if not, it'd just be impossible for them to get public housing and all these other things. And so, you pretty much made it super hard for them to survive in society. And so they end up, or at least in society, and be law-abiding. And so they end up committing more crimes, and then we throw them out the classroom again, right? Or we throw them back into a cell again. And what is it really solving? Because at some point, these people have to come back to our communities. And so as a teacher, I might think about, and you're a parent, so it might be the same thing with parenting. You might think about, okay, if my kid is crying or acting up or doing something I don't want them to do, how did I contribute to that? Maybe they needed a snack. Maybe they needed some nourishment, right? Maybe they needed some extra attention. Yada, 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 right. So in the jail context that are in a criminal context, that might be, maybe they needed mental health services, or maybe they needed nourishment, or maybe they needed education, or whatever services they needed that we as a society didn't provide them. And then when they act up, we act surprised. So
is there a model that we can use? Because I think it's Norway. Is it Norway that has?
I think I've heard it about Norway and Germany.
Their prison, or is it Sweden? One of those two.
Sweden too.
Where it's really about reform. And the person is staying there. They have like a nice place. It's almost like a hotel room, not necessarily behind bars, But those countries don't have as many crimes on the books as we do, and they don't lock up as many of their citizens as we do. So what is the alternative to, let's say I represent law and order, right? There are murderers out there and dangerous people. What do you do about them? Is there jail for them, or is there some other place for them, or do we decide no jail for anyone?
So I think prison abolition is in some ways theoretical to a certain extent. I think it makes us imagine a world without prison, and then what would you do to fix that? And so, if I know I'm going to have a classroom with murderers, and I'm going to try to think about, okay, what do I do to make them not be murderers?
Okay.
And so you try to provide those services on the front end so that these folks don't turn into murderers on the back end. But I do think there may be a much smaller percentage of the population, and you got to know we grew from 300,000 prisoners, maybe 30, 40 years ago to over 2 million now. So we have been that society where we have had less of a prison population. But there may be a certain small percentage of people who might need to be locked up. And if that is the case, what does prison look like? And certainly there are other countries
for them. What
who
resources are we going to spend our money on to rehabilitate them as well?
Right. And also, does it have to be a concrete cage, or can it look like an apartment? Can they get weekends?
Okay,
Things
so
like
we
that.
should definitely
Can it be humane?
We should definitely delve into that topic a little more. At this point, I think we do need to have some Q&A from our live audience. Let's just check in.
One question that came from the live feed was, how hard is it to get a conviction overturned on an appeal?
Well, the question is great. It's a great question. So it's extremely hard. There are a myriad of different reasons. I don't know if there's a particular stat for every conviction for a trial, or maybe some kind of a suppression we talked about in our case. That person that pleads guilty, for example, and has a good suppression issue, may be able to reserve their right to an appeal. And if the appellate court agrees, that's a good case where that would be an overturned conviction. But in terms of statistics, I'm not sure what that number would be. But if it goes to trial, I do know without any real egregious acts in that trial, the appellate courts are reluctant to overturn what a jury basically decided.
Yeah. I'll just add, when you look at the number of cases that go to trial, which in the grand scheme of all cases isn't that many, there's not going to be that many of those when they're appealed that get overturned. That said, you do see, pretty regularly across the country, there are, cases that get overturned for different reasons. And so, it happens.
Prosecutorial misconduct,
right.
Hiding evidence, DNA evidence. The Innocence Project is doing great work. False confessions. I think of the Central Park 5 guys. I think one or two of them went to trial. I definitely know the tallest one went to trial. And, it took somebody to confess to the crimes later on. Those are outliers. The majority of the trials that are ending up in a conviction, though, without some other evidence of innocence or misconduct, it's kind of hard to just rely on, the judge made a wrong ruling on, an objection I made, that kind of thing. It makes it really tough.
We have some questions and we have some comments. Another question, even though this wasn't one of the topics, was, does Trump's pardon give recipients an immediate release?
Oh, so there's, commutation of the sentence, and then there's pardoning, right? So I think that's pretty much immediate. They have to be let out right away. Some of them will still have to deal with maybe supervised release. I know Lil Wayne and Kodak Black were two guys that received pardons from Donald Trump, and they'll be out probably by the time this airs.
One of the comments when you guys were discussing the anatomy of a case was, is the gun stolen or registered?
Very good question. That actually bumps up the amount of time. If the gun is stolen or found to be stolen, that becomes an issue for the conviction at sentencing. If it's a registered gun, if it's registered to that person, that's probably a bad bit of evidence against them, I would say. But if it's registered to say random John Doe, but it's not
Or friend in the car.
or the friend of the car, right?
That's helpful.
It's helpful. So it just depends on what stage of the case. If it's if you pled guilty, that's going to be used against you as a stolen. That's going to bump up your time exposure. If it's you're fighting to go to trial and it's not registered to you, and there's no chain of custody that ends up with you having the gun, maybe that's good evidence for you.
Another comment was on the topic of the Kirbyjon case. It said this was just a comment. At the end of the day, the bonds were worthless at the time of the offering to the public.
Yeah, and that's
That's
partly
not
where,
the end of the day, though.
That's partly
not
that's partly
end of the day.
problem.
Really is.
That
Did
is
he
part
know
of the
that?
problem.
Did he know that? That's really what the end of the day is.
Yeah, and in your defense, he should have known it. I think is partly what the judge was saying. Even if you didn't, you had the means to figure it out. Like, you're a businessman.
Should have known is not the standard.
No, that's why I said in your defense.
Yeah.
I think the judge made that clear that, you're a businessman. Even if you didn't know, you had the resources to find out, and you should have found out. And ultimately, it is what it is.
If a judge did that, that's a good. I mean, that was like a trial case, and it was the evidence basically found that, then that would be a good way to get the case overturned, because the standard is not that. The standard is, did you put your head under the sand and consciously disregard something? So it's a little different. But like I said, those cases suck. They're hard. So we could go on and on about that forever.
Yeah. And not to mention, there was also money laundering charges, which bring a whole other wrinkle to the case. Where did the money come from? Did you have reason to know that the money was illegitimate? Did you go through the proper procedures of when you get $50,000 or anything over $10,000 and file it away properly? All those things. So there was a lot of exposure that that Pastor was actually looking at, and 6 years in the grand scheme is a lot for a gentleman
For white collar crime.
For a white collar crime, his age, his medical condition, and we saw other people commit crimes against America, like Manafort and such, and didn't get anywhere near 6 years. So in comparison, it's a little unsettling that he got so much time.
Here's another, just a general question for both of you. Someone said, out of curiosity, have either of you ever turned down a client because you didn't believe him?
No. Didn't believe he did the crime or didn't do the crime, I guess.
It just
And
said,
say,
have you ever turned down a client because you didn't believe them? You didn't believe the client.
No. I mean, no.
And you know what? Honestly, I'm not one of those people that asked, did you do it anyways? I kind of just like, you know what? You have a right to representation. These are the charges. We walk you through, like we talked about the anatomy. I don't really need to know if you did it or not, because ultimately that shouldn't affect how I represent you. But if I'm asking you questions, I do need to have an answer, because I'm asking for a specific reason. And if you're going to lie to me, just know that could hurt you. It's like they tell you, don't lie to your doctor, your lawyer, and maybe even your mama.
This is two questions. One is, should cases go to trial? And the second part of that question is, whatever happened to the right of a jury trial? Should cases go to trial, and whatever happened to the right of a jury trial?
So I definitely think more cases should go to trial. We basically have a system now that processes, it's a mass incarceration system, so it processes way too many people. And so given the numbers of people it processes, prosecutors have created the situation where they penalize you. So it's like a trial penalty if you go to trial. And so it's so risky to go to trial that so many people don't. So I think like 97% of the cases plead out, because if you were to go to trial, the prosecutor's just going to throw the book at you if you were to lose. And so I do think, as we talk about even in this case, like, I didn't read the plea agreement. I didn't even read the indictment, really. So I'm not really sure of all the things the government is alleging. But just hearing it as a lawyer, as a defense lawyer, I'm like, there's another side to that story, right? And I do think
There is.
trials really do a good job of kind of allowing that evidence to get fleshed out, the trial process, because you have witnesses coming in, you have all this evidence coming through that has to be presented in a decent kind of basic way to a jury, so you really get down to the nuts and bolts of what's going on. And so, yeah, I think there should be way more jury trials than we have now. And I think most, or maybe not most, but a lot of people would agree with that.
Yeah, and in fact, you have a right to a jury trial. When you plead guilty, you are giving up your right to a jury trial. And they will ask you, are you aware that you are giving up your right to a jury trial? So absolutely, being a member of a jury is a huge responsibility, and it's a huge honor. They fight for voting rights. They take away your voting rights if you have a felony. You have to fight to get them back. And one of the consequences of a felony is not to be able to serve on a jury. And we need people to be on juries. We need broad and diverse jury pools.
I think that'll make a good topic for one of the future episodes, the importance of serving on the jury. Just a point of information someone wanted to point out was that in the Kirbyjon scenario, he was an investment advisor.
Okay. Well, I think at this point, this probably is our time, wouldn't you say?
Yes, it is.
All right.
Okay.
So
Y'all have one more question, but y'all can table it
we can
for
table
the
it
next
for
one.
the next one with our final word. Aisha, please.
Yeah, thank y'all so much for tuning in to the third episode of the Do Not Consent Project. We do want to just end with that reminder: do not consent to police searches. If you have the choice, tell them you do not consent. And we will see y'all next time. Thanks so much.
Thank you.
Haven.